Thank you. The meeting of Criminal Law Subcommittee of the House Courts Committee will come to order. Clerk, please open the roll. Members indicate your attendance, your presence. And we have a quorum. Now, it's a moving docket. Even though this is getting now, the clock is ticking towards the end of the session, I'm such a good chair that I'm going to allow all of these requests to go forward. The first one is, and on this one I would, however, a motion to incorporate will be in order before we take it by for the day. I think that's appropriate parliamentary sequence. And that is HB 687 will be incorporated. I have a motion is in order to incorporate it into HB 1029.
Madam Chair.
That's a voice vote.
I'll move to incorporate HB 687 into HB 1029.
Second.
Okay. And with that, there is a request to go by for the day. Do I hear a motion? Voice vote.
Second.
The next request is for HB 637 to go by for the day.
So moved.
Second.
And the next request is HB 862 by for the day.
So moved.
On all of those, I should have said, all those in favor say aye.
Aye.
All those opposed? And I will so apply that. Then what I see on the docket that would remain will be HB 690 and HB 1028. Later, there will be a motion to incorporate. I'm just going through the docket. The others also still on the docket is HB 1070, Rasul, who is in the room, HB 150, Williams, HB 441, Hope, and HB 561, Hope, correct? All right, then, if I may proceed then with Delegate Rasul, if you're ready to go forward, that would be HB 1070, and there is a substitute.
Thank you, Madam Chair. Members of the subcommittee, there is a substitute for your consideration. Thank you, Madam Chair, members of the subcommittee. The problem that we have before us that we're trying to solve is prejudice of the jury and understanding that when in certain circumstances that they are aware of a prior conviction, how that may prejudice the jury. What we understand is through the Sixth Amendment that everyone has the right to a trial by their jury of their peers, and then they can waive that. Waiving, in this case, what we're talking about is waiving a portion of that, creating a process, as it is in many other states, where the judge would then take into consideration if there is a prior conviction or adjudication for their consideration and note that for the record, and then the remainder of the trial would then be presented to the jury without that. The substitute that is before you does carve out a slightly different process for certain crimes involving firearms, schools, children, and providing false information. So this has been left to the states, Madam Chair. What we have found is that the Virginia Court of Appeals has said that the states can set this procedure by statute as we move forward. There is no constitutionally required procedure for prior convictions at trial. What this does not do, Madam Chair, is reduce a sentence for anyone. It simply says that when we're presenting the information, that if the defendant chooses to, they can forego and waive the portion of their trial that has their prior conviction going to the jury. Instead, that is first to be presented to the judge for court record. Happy to answer any questions, Madam Chair.
I see several individuals. Mine is not on the list. Delegate Davis.
Thank you, Madam Chair. Question for the patron. So with this bill, you do not want the jury to hear that the defendant has a prior conviction. Is that correct?
Correct, Madam Chair, Delegate Davis, that is correct, except for the exceptions. There is a slightly different process if you look in B, and it talks about there are sections of the code where there would be a separate process laid out.
Thanks.
Follow-up? Are there any other questions? Hearing none, seeing none, is there anyone in the room who wishes to speak in favor of HB 1070? Anyone wishing, are you here to speak in favor? Anyone wishing to speak in opposition, please come forward.
Good to see you again.
Good to see you. Good evening, Chairwoman and members of the subcommittee, and I thank you to the patron who sat down with VACA. We expressed our concerns, and he was good to listen to us. VACA opposes HB 1070, and I'm Bethany Harrison, Commonwealth's attorney for the City of Lynchburg for VACA. We are concerned that this bill is open to a Virginia constitutional challenge under Article 1, Section 8, and this is why. The Virginia Constitution favors trial by jury, such that all three parties to the jury, the defendant, the court, and the Commonwealth, must all waive a jury trial in order for it to be a trial by judge. And this is different than sentencing because in the Virginia Constitution, it specifically lays this out for the guilt phase of trial. So under subsection A for this bill, it requires the Commonwealth to accept a bench trial when proving the certified prior beyond a reasonable doubt. And we're concerned this would violate the separation of powers here. And for subsection B, we have this overriding the existing case law that the Commonwealth is not required to accept a stipulation of evidence, as well as historically we've been able to deal with whatever prejudice may come from entering the certified prior conviction with a limiting instruction to the jury trial. We have concerns about amending the required indictment language that we're required to put in the charging document, and I guess censoring it, editing it out in such a way that will cause confusion and chaos in our jury trials. So, for example, for someone who's charged with failure to register as a convicted sex offender, you put on the person from the sex offender registry and you say, "Hi, my name is whatever, where do you work?" And I mean, what are they going to say? "I work for a registry." Why does this person have to register? Well, this person has committed an offense. Mistrial. We have to get that information in about why they have to register, which determines the frequency of registration and why this particular date of offense would be the date of offense for the violation. So that's just one example. Also, it seems incongruous with our current rules of evidence allowing for other prior bad act or even conviction evidence to come in. Under 18.2-67.7:1, you're allowed, once you meet certain requirements, to put in evidence of similar crimes in child sex offense cases. So while we'll clean up the indictment for any of these offenses that are building offenses or require a certified prior, but you can put in evidence of prior child sex offenses. So what's more prejudicial there? You can put in certified priors in use for impeachment, and we're not saying this bill would prevent any of that. We're saying it would give kind of strange results. You can have other purpose evidence in your case in chief where you can enter in the certified priors to show knowledge, motive, lack of mistake, relationship between the parties, premeditation, and other intent. And certainly you can also use it for rebuttal evidence. So for these reasons, VACA is opposed to this bill. Thank you.
First, take testimony online before we proceed with some of the questions raised. And online, I have 4 individuals who have registered to speak for HB 1070, and those individuals are first, Tina Ramsey. I do not see her online. The only person that I see online is Brad Haywood. Brad Haywood from Justice Forward.
Good afternoon. Brad Haywood with Justice Forward, Virginia. When Virginia still had a felony petty larceny law, I always asked the following questions during voir dire. Show of hands. Would you be more likely to convict if you learned my client had a prior theft conviction? A couple of hands would go up. Then I'd ask, what about 2 prior convictions? A few more hands would go up. And then finally I'd ask, what if you learned it wasn't just 1 or 2, but 5 prior theft convictions? Almost every single hand would go up. All of those jurors would be struck for cause, and the judge would declare a mistrial before even the first witness was called. The reality is, though, that most hands probably should have been raised after the very first question, and it's just human nature, which we can all relate to. You are most likely to convict, you're more likely to convict if you learn the defendant committed a similar crime in the past. Over time, my voir dire has stopped working, not just because that law was repealed, but it doesn't work in other cases either. And that's not because jurors have become more enlightened, but it's because judges have found ways to dull the impact and ignore the existence of bias. This is still how many judges and prosecutors address bias with respect to enhancement crimes. They will, quote unquote, rehabilitate the juror.
If you could wrap up, please.
Sure. They will cross-examine them, said something to the effect of, well, you can still be impartial, right? So the bias is still there. The system just chooses to ignore it. This results in defendants being deprived of their Sixth Amendment rights. This bill simply bifurcates the process. Enhancement still exists, but juror bias is minimized and constitutional rights are honored. We ask you to support the bill.
Thank you. Is there anyone else who's actually online who is registered? Thank you. That then concludes the public testimony. If I could return to counsel to address any of the questions that were raised.
Yes, Madam Chair, thank you. So as the patron kind of laid out, this sets out 2 processes. The first process would be that if the prior conviction enhances the offense, so possession with intent to distribute. Third offense, where the Commonwealth has to prove that the defendant has 2 priors. So in that instance, the individual would have to make a motion prior to trial, and the court would have just a hearing that would be very simple. Did the defendant commit those 2 priors, introduce the certified priors, like the first thing the Commonwealth does in a jury trial when they have to introduce the certified prior? And that way, the jury is not informed first thing out the gate, he's charged with possession with intent to distribute, third offense. The jury would just be told he's charged with possession with intent to distribute. And the jury would make the determination about whether he possessed the drugs and whether he intended to do them. And the judge would make the determination, does he have those 2 priors? So this would eliminate the prejudice that comes from the prior bad acts. With regard to the prior bad act evidence, the rules of evidence actually create a higher standard for putting that information into evidence. The normal standard for relevant evidence is it substantially more prejudicial than probative to keep it out? When it's a prior bad act, the probative value actually has to outweigh any incidental prejudice. So although the Commonwealth said, yes, sometimes we let prior bad acts in, there's this higher standard of proof because courts have said this evidence is so prejudicial. This would allow for elimination of that because the first thing a jury would hear is not that they have 2 prior felonies. Because in a normal jury trial, jurors don't know that the defendant is a felon unless the defendant chooses to testify. In cases in which it's a firearm by felon, a failure to register as a sex offender, or those other types of status offenses, then you go to subsection B, and in subsection B, the defendant would have to stipulate that they are that status offense. So I stipulate that I am a convicted felon. I stipulate that I am a person required to register. And then we would do what's required by subsection B. And this is kind of like the codification of the Old Chief case that came out of the U.S. Supreme Court, where possession of a firearm by a convicted felon in federal court, a defendant had offered to stipulate to that prior conviction. The government had said no, and then the Supreme Court said, yes, when a defendant offers to stipulate, there's no relevance to introduce this prior conviction. Virginia has not gotten to the ultimate conclusion of Old Chief. They've gotten close, but the facts have not been there where the defendant either didn't offer to stipulate or the defendant didn't preserve the issue for appeal. So this would essentially be codifying in subsection B the Old Chief language from the Supreme Court that the appellate courts have not yet gotten to. if that answers any questions.
I'm going to just, before I recognize Delegate Williams, I'm just going to clarify. So as I heard the very last of what you had said, as far as codifying what other states have done, that we have not at this point come quite there. Is that in any way related to the comment by Vaca having to do with Virginia's Constitution?
Well, the comment by Vaca with regard to Virginia's Constitution, I think would only be implicated by subsection A. And I think it's really just a procedural issue. The judge has the ability to determine this, and the statute would allow that. It doesn't in any way prevent the other evidence from going to the jury about the defendant's guilt with regard to just what are the normal statutory elements. The only issue that would be heard by a judge is, do they have these prior convictions? Is this a possession with intent second? Is this a possession with intent third? Is this a DUI third, where they just have to essentially introduce the two priors, and that's the procedure for doing it?
Thank you. Delegate Williams,
Yes, Madam Chair, had a question for counsel.
please.
I was wondering, because it sounds like you're saying this, does this shift, does it split and shift off one of the elements for the jury finds the majority of them, and then these, aggressive or aggravating concerns, the predicate type stuff, the judge hands that off? Judge takes care of that, but the jury weighs in on everything else?
That would be the procedure if it was subsection A. So it wouldn't change the burden of proof. The Commonwealth would still have to prove that element beyond a reasonable doubt, but just those priors wouldn't be heard by the jury. The judge would make that determination as to the first element, and then the jurors would make the determination as to the rest of the elements.
Madam Chair, follow.
And sorry, just Mr. Hatcher wanted me to outline that if a defendant does not make the motion to do this, then the jury would hear all the elements and determine all the elements.
Delegate Williams?
Yeah, question for the counsel.
Mm-hmm.
And so in the guilt and innocent phase of trial, if one of the elements is, whatever, firearm, whatever, will the jury ever learn about that because they need to find him guilty of, felon in possession of a firearm? Will they learn that? Or will they think that, it's only 4 elements, but there's this 5th one that the judge decides?
So it depends on which procedure. So if it's a firearm felon, as I understand it, there's going to be a stipulation that, I am classified as this. That would be introduced to the jury. Okay. That part under B. Okay. So for those status offenses, because one of the things that we pointed out in discussing the language of the bill is originally it only included A, and I suggested, well, how would they know about a firearm felon if the elements are just he possessed a firearm, because people can legally do that. The jury might be wondering why. So that's why subsection B was added for those status offenses. So the jury would receive a stipulation, hey, the defendant has stipulated that he is this status offense. So then and you have to accept that, and that's proven beyond a reasonable doubt. So the remainder of what you need to determine is, did he knowingly and intentionally possess a firearm, and was it a firearm? So that would be under B, not under A.
Okay, and then I have one follow-up.
Proceed.
I think, I can't remember his name. He mentioned voir dire, so I don't do a lot of jury trials, honestly. So in front of voir dire, aren't we allowed to discuss prior criminal history? Are we not allowed to discuss that in voir dire before jeopardy even attaches?
Right. So in voir dire, you can't mention a defendant's, the Commonwealth can't mention a defendant's prior criminal history. I mean, I guess technically you could if the priors are what we're dealing with.
Right.
Like, for example, you might say as a defense attorney on a firearm felon case, I know I've said, the first thing you're going to hear is that my client is a felon.
Yeah.
Similar to Mr. Haywood saying this, and you do try to weed people out.
Right.
But ultimately, when the first thing a jury hears in those circumstances, hey, he's a felon, hey, he's got 2 prior possession with intent. But normally in a jury trial where that's not an element, you can't mention a defendant's criminal history.
Okay, thank you.
Thank you. Seeing no other hands, Delegate Davis.
Thank you, Madam Chair. I just have a comment. As a criminal defense attorney, I like this. As a citizen, I don't like it because I don't think the jury's hearing all the relevant evidence. So I just wanted to make that comment.
Thank you for that stipulation. Seeing no other hands, and Counsel, do you have anything else that you wish to share at this time? I think then you have the final word, Delegate
Thank you,
Rasul.
Madam Chair, and to Delegate Davis. I hope he votes as a criminal defense attorney today. But I will say, and thank you to Counsel for highlighting the extremely high bar that we have set as a society with regards to the introduction of evidence that shows that prejudice of prior that can induce that prejudice when we're talking about prior convictions. Just to reiterate, there are many states that have already done this, or iterations of this, including West Virginia, et cetera, including the Commonwealth of Virginia for 120 years did it this way until the 1920s when things changed. And lastly, just to underscore that the Virginia Court of Appeals has opined that we can, in fact, do this.
Thank you, Delegate. We operate by motion. Is there any discussion of a motion to report? And I don't think the substitute, yes, yes, please. So it has been moved and seconded that we report the substitute. Is there any discussion on the motion? Seeing no one, please, clerk, please open the roll. Members, cast your vote. The HB 1070 reports with substitute by a vote of 7-3.
Thank you, Madam Chair, members of the committee.
Thank you. Next, then, on our agenda, looking at the members that are in the room, would be Delegate Zur and Delegate Walker. They both have identical bills, and a motion would be in order to incorporate 1028, which is Walker's bill, into HB 690.
I'll move to incorporate House Bill 1028 into House Bill 690.
Second.
All those in favor say aye.
Aye.
Opposed? Okay, but you both may speak to the issue as patrons. Proceed, Delegate Zur.
Well, thank you, Chair. You've been very gracious in accommodating us on this rather confusing incorporation here. This bill is brought on behalf of local Commonwealth attorneys and is supported by the Virginia Association of Commonwealth Attorneys. Under Virginia Code, law enforcement officers are required to leave a copy of both the search warrant and the supporting affidavit with the occupant or owner at the time the warrant is executed, even when a judge has issued an order sealing the affidavit from public disclosure. Subsection A of the code, which deals with non-residential warrants, explicitly exempts sealed affidavits from the requirement to provide them to the subject. Meanwhile, over in subsection B, pertaining to residential warrants, there is no such exemption, even though this document is sealed from the public. This can then oftentimes defeat the purpose of the affidavit being sealed in the first place, as it forces investigators to give out highly sensitive details, such as informants, surveillance results, cooperating witnesses, etc., directly to the subject or people closely connected to the person who is the subject of the search warrant. This can lead to the flight of suspects, destruction of evidence, witness intimidation or harm, or any other number of grave consequences. Thus, this legislation would remedy that issue by specifically granting that when an affidavit has been sealed, the affidavit is not required to be provided to the resident of the place to be searched. This will provide the same temporary protection for ongoing investigations in residential searches that already exists for non-residential searches, while preserving the defendant's right to see the affidavit once the seal is lifted. Thank you.
Thank you. Delegate Walker, did you wish to add to that open statement?
Madam Chair, I'm not sure how much more I could add to it. I think my comments were very similar, but basically this is just a technical issue in the code that the police must leave behind after you've heard serving the warrant. And so without further ado and time, I think Mr. Delegate Zaire has given you the full extent. Our Commonwealth Attorney is here if there's any questions to speak to that. I think it's just a very simple fix. Hope that the committee will find favor with that. And thank you for allowing our other bill to go by till we can fix that again. That's it, Madam Chair. Thank you.
Thank you. Are there any questions from the committee? I have a basic question, and I'm looking to make sure of who is. I don't see anyone scheduled to speak on this, so I would like to, in fact, call the representative of VACA forward to ask this question, but perhaps also counsel. So what I heard was that there would be information in the affidavit that would be very damaging to law enforcement's efforts. Now, what I've been told is that typically that if you have an ongoing criminal investigation, you wouldn't have a warrant. You'd normally just go to the people directly based on probable cause. Where's the truth in this?
Chairwoman, I'm sorry.
Or is the truth that I don't understand it?
You can have all the above. So you can have instances where you have someone already in custody, but there's still an ongoing investigation. You can have continuing criminal enterprises. You can have co-defendants or other, collaborating suspects in the case. But just because someone is arrested does not mean that the investigation is over with. So I hope that answers that question.
And so you're saying that in those instances that you're referring to, you would need to have a warrant, that you wouldn't have a reason without a warrant to approach that person, go into the enclosure?
Well, for places of abode, you have to have a warrant. I mean, there are some exceptions to the warrant requirement, but places of abode are especially protected and where you would want to have that search warrant. And along with that comes the affidavit that has information about the criminal investigation.
Counsel, the question, and I used the wrong word, but to indict someone directly?
That deals with the other bill that was passed by. This is about the search warrants for the place of abode.
I was conflating the two because
Correct.
The procedure of, okay, so you're saying that.
This is about the search warrants.
All right,
yes.
so it's always that because you're going in an enclosure, you're always going to need a warrant.
Almost always. There are there's always an exception to the warrant requirement, but this statute deals specifically with search warrants, and the only amendment, it's now required that prior to searching a place of an abode pursuant to a search warrant, you have to give a copy of the search warrant and supporting affidavit to the owner of the house or to an adult if the owner isn't there, or if nobody's there that's an adult, you leave it. The question here is, do we have to give a copy of the affidavit if the affidavit's been sealed by a judge? And kind of how courts are interpreting this is that they're split. Some judges are saying, well, obviously you wouldn't give a copy because it's sealed. And some judges are saying, well, the statute specifically says give a copy. So it's depending on the circuit and the judge you're dealing with. So this is, I guess, the purpose of the amendment.
Yes.
With bringing you forward, would you like now to speak on behalf of the bill?
Yes, thank you, Chairwoman. So I'm Bethany Harrison, Commonwealth's Attorney for the City of Lynchburg, and here on behalf of VACA that supports the bill. And just to add to what was already said, our circuit, our court, is one of the ones that suppressed the evidence because even though the officer was acting, knowing that the search warrant affidavit had been sealed in the circuit court pursuant to the code that allows for that, subsection A is for all other search warrants where if it's sealed, you do not have to give over that affidavit, but subsection B deals with places of abode. And our judge held, consistent with an opinion that was issued out of the city of Alexandria, stating the same thing, that absent that specific language in subsection B, that the court could not find that there was an exception the sealing allowed the officer to not hand over the affidavit. And the Commonwealth has no right to appeal statutory suppression. So our only remedy here is to ask for an amendment to this code section to make it clear that if we are in the exceptional circumstance of having to apply for a separate order to seal the warrant and affidavit, that it could be treated the same as subsection A.
Thank you. Are there any questions, comments of the committee? Again, is there anyone else in the room who would like to speak for the bill? Anyone here who would like to speak in opposition to the bill? Delegate Davis.
Thank you, Madam Chair. I have a question for the VACA representative. And I was reading something, you may have said it, but what type of case was this that you're talking about?
The one we had in Lynchburg, we were helping another jurisdiction in a homicide investigation. And so there was a weapon inside that was suspected to be the murder weapon. And while we did not have the homicide case, we found other evidence. In another case, that evidence was suppressed. And so that case was done.
Thank you.
Are there any other questions? Seeing no one wish to speak, members, we operate by motion to whether or not we need this clarification or how we should proceed. So you move to report, and the moving to report then is that basically if the affidavit is sealed, only the search warrant needs to be provided under all of our other protections. Right. It's been moved and seconded. Any discussion? Members, seeing no discussion, please cast your vote. Then the HB 690 as reports with substitute, and again, you would need to re-sign on to the bill if you wish to be a chief co or co-patron.
Thank you very much. Thank you, Madam Chair, Committee.
Okay. Next on our agenda, then, I'm going to take, I see Delegate Hope has left the room. So Delegate Williams, you're the next one on the agenda. And I believe we have a substitute?
Yes. Yeah, I'd like to move the substitute.
It's been moved and seconded. Substitute 150. All those in favor say aye. Opposed? Okay. If you'd like to speak to the bill or the substitute.
Yes, Madam Chair. This bill, it tries to capture what is current case law with regard to speedy trial when tolling would attach based on the motion of the defendant to continue the case. This is specific to continuing the case in order to retain counsel. So what we've had recently is we had a gentleman who said that they're going to go retain counsel. That drug on 30 days, another 30 days. Finally, they did get counsel, and they came in and they moved for, violation of speedy trial, and the case was dismissed. And that person was a hired hitman in a murder case. And so this would help make certain that it's clear that if the defendant or the accused is asking for time to get an attorney, then they should be given that, but we need to move the case along, and it can't be used to defeat speedy trial just because you delayed it. That's what the bill does.
So my basic question is then, isn't the waiving of speedy trial occur with or without this review?
As it stands right now, my understanding is the law is if I'm first appearance with the court, I'm not going to waive speedy trial unless there's some reason to. And then at that point, I would have said to the judge, I'm either going to accept a lawyer or go get one. And in this case, they did not accept a lawyer. They said they were going to go get one. So, like under the case law, it's exactly what you just said, which is I can ask for a continuance, and then that time cannot be held against the Commonwealth because I'm the defendant. I've asked for some time. This is intended to codify that with the provision that we're going to try to do this on a 30-day basis so it doesn't just keep dragging on. Somebody say, I'm going to get one, I'm going to get one, I'm going to get one, and they just never do. And that happens, and sometimes the judge ends up appointing a court-appointed counsel to be on standby. It's not a great system right now. So this is just meant to guard against sort of that abuse of continuing and then playing the speedy trial card. That's the part that this is trying to attack.
I'm sorry, I need to follow up to make sure, and your last statement began to get to it. So speedy trial is to protect the defendant. And you're saying that you, however, see defendants who don't want a speedy trial and are using this delay and I can't get counsel as a reason not to go to trial.
So what is actually happening is, you've got that window on speedy trial. So they're not asking to waive speedy trial, and they're not asking to delay significantly. What is happening is speedy trial is running. They are seeking an attorney, and they're getting the advantage of the clock running out. And what we're saying with this is, while you're going and getting a lawyer, we're going to pause the clock. As soon as your lawyer files, we're going to start the clock again. So you would still get your speedy trial deadlines of 5 months and 9 months, but during the time period where you weren't able to get a lawyer yet, it's just going to pause. That's all it's doing. And, counsel's probably super good at explaining stuff like this, so I would defer to her.
If counsel could clarify, that would help me.
Thank you so much for saying that. I am very well versed in speedy trial. I just had a case in the Court of Appeals. There's statutory speedy trial and constitutional. The statutory speedy trial that we have under 19.2-243 says that a defendant shall be tried if they're held continuously within 9 months of their case being certified or them being served with an indictment. If they're out on bond, it's 9 months. That's the speedy trial window. There are certain things that toll speedy trial. Those are outlined in the statute. The Court of Appeals has also interpreted that to include other things that are not in the statute. The current things that toll speedy trial are continuance on a defendant's motion. That tolls speedy trial. So in this scenario, and obviously I wasn't present in court, but any continuance on a defendant's motion already tolls speedy trial. Any continuance on a Commonwealth's or court's motion that the defendant does not object to already tolls speedy trial. In this amendment, the initial setting of a court date does not toll speedy trial. So if I go to court for an arraignment and I am appointed counsel on that date and the court sets a status date 30 days out, speedy trial is running. If I got appointed counsel, I had counsel from that date. If I go to court for an arraignment and I say I'm going to retain counsel, normally what a court will do is set a very quick attorney status date for the defendant to come in and say they have counsel. That delay does not toll speedy trial. This amendment would say any delay the defendant has, any delay in retaining an attorney would toll speedy trial. Now, if the defendant came back to court on that attorney status date and said, I have not retained a lawyer, I need more time, That's a continuance on the defendant's motion that would toll speedy trial. So the only thing would be that minimal delay. Now, I'm not sure in this instance what the court ruled, and I'm honestly not sure why the Commonwealth didn't appeal, because I think the Court of Appeals would have shot that down in a second, because those would have been continuances on the defendant's motion. So I don't know if the patron knows if the Commonwealth appealed or not, because they do have the right to appeal a violation of speedy trial. And I'm not sure, because the Court of Appeals would have resolved this immediately and would have said those were continuances on the defendant's motion that told speedy trial. So I think it's already covered by the statute, if that makes sense. But yeah.
I'm going to try to restate what I think I understood, and then we'll see whether I understand if it makes sense. So basically, you're saying that what this bill before us does, that anytime you can't get counsel, you've got the dilemma, you've just waived speedy trial.
No, told.
Not waive. Make sure we say toll. Waive would mean you waive it forever. Toll, it would be tolled for the period of time between that arraignment and when the court sets that attorney status date. That could be a month, and that would be a month that would otherwise be running for a defendant who has an attorney at arraignment. So someone who gets a court-appointed counsel at arraignment would not have that speedy trial toll. And ultimately, as the cases have said, and as they've interpreted under constitutional and statutory, is that the burden is always on the Commonwealth to make sure the case is set within speedy trial.
And that's what happened.
So, again, that is the Commonwealth's burden.
But to the degree that I'm recognizing myself, to the degree that I'm dealing with an indigent person who needs to have court-appointed attorney, and there is or is not a public defender's office in the da-da-da-da, that person may not be able to get an attorney immediately because there's not always someone waiting in line to serve the indigent person. What happens to that individual in this scenario? Do they then have to automatically waive speedy trial because they don't have an attorney?
Based on the amendment, if the person does not have an attorney either appointed to them at arraignment or retained at arraignment, which is very rare because people don't usually know they're going to be arrested unless they know and then they turn themselves in with an attorney. Any delay to get an attorney to set that initial court date, this would toll speedy trial. That's the only change that this would have, is that anytime a defendant initially says, I need a lawyer, between this and that next court date, it would toll speedy trial. Otherwise, any continuances on the defendant's motion are always going to toll speedy trial by statute. It's already in the statute.
Madam Chair.
Yes, please.
I don't know if this is on, but to her point and to your point, if I'm indigent and I'm showing up at the very first appearance, that's when the judge is asking me, do you want an attorney? If you can't afford one, we're going to give you one. So indigent folks should get an attorney right then and there. Now, some of them are indigent, but they want to go hire somebody else. This is supposed to allow that person or somebody who's not indigent to go hire somebody else. And what we were saying is, while you're doing it, you don't get the advantage of letting the time run out on the clock. And this is saying, we'd also like to hear back from you within 30 days. I did not put any kind of you can only do this 2 times or anything like that, because it's going to happen. I mean, COVID happened. It's a thing. So that's what it's trying to do, is just sort of hey, come back in. Did you get one? No. Okay, well, we're still not going to give you the advantage of running out the clock.
Is there any, I see no one else requesting to speak. Is there anyone in the audience wishing to speak for HB 150? Anyone wishing to speak in opposition? And I see one person online, and that is Blake Villa. And that person had signed up previously and was not online, so I'm assuming that that person is not available. Therefore, you have the final word.
I appreciate you guys thinking about this issue. I appreciate council doing such a good job, like helping us through it. Thank you.
Move to report.
It's been moved and seconded to report. Any discussion? All those in, clerk, please open the roll. Members, cast your vote. I guess. I could turn it over to our what is Vice Chair? Deputy Vice Chair. I have another commitment that I must make. Thank you.
Absolutely. Thank you, Madam Chair. Madam Chair, may I first start with House Bill 561? If I may?
Proceed.
Okay, and we do have a line amendment, is that right?
Amendment?
Line amendments to report?
It's been moved and seconded. Thank you. To accept the amendment, all those in favor say aye. Aye. Any opposition? The amendment is before us.
Thank
Mr.
you.
Chair.
Thank you, Madam Chair. House Bill 561, I have the privilege of serving on the Virginia Alcohol Safety and Action Program as their vice chair. And they're the commission that runs our ignition interlock and now our intelligent speed design system. And we ran this concept through them, and they support it in concept. And they're here to answer any questions and to testify for the bill. And of course, I serve with Delegate Cousins as well on there. House Bill 561 seeks to modernize our DUI penalties by replacing ineffective hard license suspensions with the option for ignition interlock devices. This is a fact, and I'm going to keep going through this point over and over. Roughly 75% of the people that have a suspended license drive anyway. And that is an important point, because if you have an issue with substance abuse, you got a suspended license, you go before court, 75% of them are driving anyway. And that makes our streets less safe. So what we're trying to do here with this bill, obviously that policy is not working. It's not effective in making our streets safe. What House Bill 561 seeks to do would be to allow judges to require ignition interlock devices with a restricted license rather than a mandatory license suspension. These mandatory suspensions that we currently do just don't work. They're not best practices anymore. And in fact, we're out of sync with the rest of the country. Our laws in this area are antiquated and out of date. A lot of states have moved forward in doing what we propose here. Other things that the bill would also do would allow judges to require ignition interlock devices for people under 21 years of age who are convicted for first and second offense DUIs. Early intervention, education through VSAP, and use of interlock and ignition devices can curb behavior in young people and adults and help reinforce safer driving. It also allows the judge to require IID in convictions where a person refuses a blood alcohol test for certain repeat offenders and in certain felony cases as well. Again, this gives discretion to the judge, but at least allows them the opportunity to do that instead of these hard suspensions, which we know are ineffective anyway. I do want to call your attention to a policy here that we just got to get comfortable with as a subcommittee, and I want to leave it to you, but I want to flag it for you. And that's on line 517, 46.2-391. These are people that have been convicted of involuntary manslaughter, maiming through the course of a DUI. These are people that have spent a lot of time in prison, maybe 10 years, 20 years or more. They come out, typically have 5-year suspension, hard suspension that they can't drive. These people are driving anyway. And so it's included that section of it. I know that these are people that have committed a crime, a serious offense. They've served time for it. But coming out of prison, we know that they're going to drive. So why don't we just have a policy that has them, if they're going to drive safely? And the ignition interlock is a proven system. Virginia has one of the best programs in the entire country. that's emulated. Why don't we pull them to the system earlier and guarantee that our streets are safe? This bill that I bring before you has been endorsed by the Virginia Chiefs of Police, Mothers Against Drunk Driving, the American Association of Motor Vehicle Administrators, and the National Highway Traffic Safety Administration. There's a whole list of here. You can see these groups with all these logos on here. I won't go through all of them, but they've sent you all a letter in support of this. They agree, going back to that original fact, when you talk about 75% of people that get a suspended driver's license are driving anyway, that doesn't make our streets safer. But we know ignition interlock does. And so that's the bill before you. I'm happy to take any questions. We do have folks here from VSAP that can answer any technical questions. You know, they're the people that operate the program, and whether or not they're able to accommodate this. Again, I want to emphasize, we brought this to the commission at our, I believe it was our December meeting, had a really good conversation about it, and the commission didn't see the language that you've adopted here, but I walked through the concept of what we're trying to endorse here, and it was a unanimous support for this concept. So I'll stop there. Thank you, Madam Chair.
Thank you, Mr. Chair. Any questions from the committee? Delegate Davis.
Thank you, Madam Chair. Question for council. So currently, if you're convicted of a first DUI, you lose your license for 12 months. You got to have the ignition interlock. So that's the same in this bill. Second offense, you lose it for 3 years. Do you still lose it for 3 years, but you can get an ignition interlock installed immediately? Okay. And for felony, Madam Chair, I'm sorry.
Go ahead and proceed.
And for felony DUI, you lose your license indefinitely. And so you can immediately get even on a felony DUI, the restricted license.
I think you'd have to petition the court.
All right. You're still eligible.
You would be potentially eligible.
Thank you.
Thank you. And I guess just, Mr. Chair, to emphasize the point that I think you made, but to clarify, this is there is judicial discretion across the board.
Absolutely.
This isn't a requirement that anyone that may have been involved in a serious crime, the judge would still have discretion to determine whether this is an appropriate measure depending on their circumstances.
Yep. That's exactly right.
Thank you, Mr. Chair.
Permissive.
Is there anyone in the audience that's here to speak in favor for the bill?
Good afternoon, Madam Chair, members of the committee, Christopher Morris with the Commission on VSAP staff. As Delegate Hope said, the staff did look into this issue with people driving suspended and how we could use ignition interlock to resolve that. We presented it to the Commission on December 4th, and they unanimously agreed to a bill in concept, which is this one, HB 561. And he is correct. AMBA, the American Association of Motor Vehicle Administrators, did determine 75% of people suspended or driving. I want to talk specifically about DUI seconds. DUI seconds, a second in 10 years is a 4-month hard suspension. A DUI second in 5 years is a 12-month hard suspension. So those individuals cannot drive for that period of time. This bill allows them to do that they can drive earlier. That's good for highway safety because we're getting an ignition interlock into the car quicker. They can also work and provide for their families at the same time. The other thing is a bill passed out of the General Assembly last year that enabled people to install an interlock prior to conviction. That works great on a DUI first. We're seeing a lot of those referrals. DUI second, a little bit of a problem there because if they put it in before court, they have to take it out for 4 months or 12 months and then come back and put it back in. This bill closes that gap.
Thank you. Thank you for your testimony.
Madam Chair, members of the subcommittee, Chrissy Noonan with Seven Hill Strategy Group on behalf of Smart Start. I want to start by thanking Delegate Hope for his work on this issue and for VSAP for starting the conversation over the interim. The statistics show, and Delegate Hope said it best, that drivers who lose their licenses continue to drive. Virginia has been a leader in DUI laws, so much so that federal law at the time when our laws were established required certain hard license suspensions. Those suspensions were tied, and the requirements for those suspensions were tied to federal highway funding. Thankfully, the thinking has evolved, and so have the federal requirements. This bill would modernize our DUI penalties and align Virginia with the majority of states and would have the benefit of increasing public safety. This is not a requirement for judges. It's a tool in the toolbox to help combat unsafe driving. There's a number of folks who would have liked to testify tonight and weren't able to be here. I did want to just mention that Washington Regional Alcohol Program supports this bill. Thank you, Madam Chair. We ask that you support the bill.
Thank you.
Madam Chair, members of the subcommittee, Patrick Cushing on behalf of AAA. Towing is a side gig. We are a traffic and transportation safety organization as well. We support the bill. I've been working with AAA for 15 years. The hard suspension was something where we were at 15 years ago. We've seen the evolution and believe this will make roads safer, providing this flexibility. So we support the bill. Thank you.
Thank you. Is there anyone in the room here to speak in opposition? And no one is online. All right, I do have a question from Delegate Williams for.
Oh, I'm sorry, that's probably.
Oh, that's old. Okay, no problem. All right, any other questions? Final word from Mr. Uberchair.
No, thank you, Madam Chair. I appreciate the time. This is one of those things. It's a safety bill, and making sure that knowing that people are going to be who they are and provide for their families. This, I think, will make our roads safer. The other thing I failed to mention is that because most states are already out in front of us on a lot of these issues, the bill does allow for a work group to come together and start looking across the 50 states and see who's doing it best practices, and maybe we'll come back in the future if this bill passes to expand on something like this.
All right, motion from the committee.
Move to report as amended.
Second. Moved and seconded. The clerk will open the roll. Clerk will close the roll, and the bill reports 9-0. Thank you, Mr. Chair. And if you'd like to proceed with your next bill.
Thank you, Madam Chair. House Bill 441, and I do have a substitute.
Move the substitute.
Moved and seconded to adopt the substitute. All those in favor say aye. Aye. Any opposition? All right, the substitute is before us. Mr. Chair.
This is a bill that I work very closely with Justice Ford and also Jerk as well, too. We spent many hours working together on making this better, and that's a substitute before you. The bill that's before you is best practices. There's a Jerk-like in every state in the country. And this is drawn by ABA standards and standards for judicial discipline systems published by the Institute for Advancement of American Legal System. And the version that I brought to you incorporates, almost verbatim in some cases, updating our statute to more modernize Jerk. What we're trying to do is modernize it, create some oversight and representation, but primarily transparency. I think the public, certainly us in the General Assembly, need to make sure we know exactly what's going on, especially when we evaluate the judges. But they also need that transparency as well, too, when they get complaints and making sure that they have the full picture. What the bill does is it expands the number of commissioners from 7 to 12. This will make sure that we have equal representation from judges, lawyers, and non-lawyers. And that's promotes under 17.1-902. It promotes full investigations with input from complainants and witnesses. It also has a provision that requires training on ethics when new members come in, making sure they have training on ethics and judicial canons. Enhances transparency by requiring codification and publication of their code of conduct, their conflict of interest policy, as well too that in interventions and sanctions when they are used. It also enhances transparency for interventions in specific cases by mandating reporting of actions taken. That's under 17.1-902.1. It also ends the siloing of judicial performance evaluation program by allowing the Jerk access to that information, that evaluation information that we on the courts committee, we're looking at, but we want to make sure that there's that two-way street when they're evaluating and creating a standard. And it tries to create a standard in there that will be confidential, but when that is triggered and when they're able to see that information as part of that record. And so that's the bill that's before you. Again, I don't think that the bill before you is controversial at all. In fact, as I said, we did have many conversations with counsel from Jerk, and I think reached to a very good place to where the bill is. I have worked with OES. They've probably just seen the newest version now, and we wanted to make sure that it's also workable for them as well too. And I don't know if they've had a chance to review it as well, but But certainly, this is one of those products that I think our jerk laws just have not been updated, and this is a reform that really brings them up to best practices across the country.
All right, thank you. Any questions from the committee? And is there anyone in the room that would like to come speak in favor of the bill? Is that just a thumbs up? Is that, you're not here? Okay, sorry, misinterpreted. Anyone here to speak in opposition?
Not really that either.
Okay, well, come on up. Let's hear it.
Madam Chair, members of the committee, my name is Brandy Singleton. I'm the Director of Legislative and Public Relations for the Office of the Executive Secretary of the Supreme Court of Virginia, which is a mouthful. We do not have, just to be clear, I just want to clarify the landscape here, and then there are a couple of lines in the substitute that I want to bring your attention to. First of all, the Office of the Executive Secretary is a separate judicial branch agency from the Judicial Inquiry and Review Commission. We do not have oversight over them. They are entirely in a separate judicial branch agency. In the Office of the Executive Secretary, we run the Judicial Performance Evaluation Program. That program, as originally conceived, has 3 parts, one of which is self-improvement for the judges. There are 3 stages in their term at which they are evaluated. The first is after that first year on the bench. The second is midterm. That's the self-improvement piece of it. The only people who see those evaluations are the judge themselves and their peer evaluator. And then the third set of evaluations is the one that comes to you when they are up for re-election. And that allows you to see, after some period of time and some opportunity for self-improvement, if there were some initial deficits, that lets you to see, as you are looking at whether or not to re-elect them, how they have done throughout their term. So that brings me to lines 33 through 36 of the substitute. What I heard the patron say is that the intent is that JERC gets the same information that y'all do. If that is the intent, we have no objection to that. If the intent is that JERC gets all of the evaluations, even at the self-improvement phase, that is problematic because it then takes a tool that was meant to be educational and for self-improvement and turns it into, it weaponizes that and then deprives it of its value as a tool for self-improvement. If all of the evaluations. So I don't know what. The mid-year, the midterm? Yes. Okay. Yes. So if that is not the intent, the language just needs to be cleaned up some because it's pretty broad language and it wasn't clear to me upon first read what it was intended to capture. And we can work with the patron if that's your intent. What I said about JERC not being part of OES, that brings me to lines 71 through 74 in your substitute. I'm not sure, and I would need to talk to Benjamin. I don't think Benjamin wants me teaching him about ethics. I'm not sure that OES is the proper entity to train commission members on the canons. I think that might cross some lines of propriety in terms of the separateness of the two institutions. And then finally, back to the use of the evaluations, that brings me to lines 142 through 149 of the substitute. And again, if what is being presented to the commission is simply that which is given to you upon re-election, then that is fine. That's a public document at that point. And if you want to mandate that that's a piece of the information that goes to the commission, that's your prerogative. It is my concern that it only be the same information that you're getting if anything's going to go to the commission and not those evaluations that are designed for self-improvement of the judges.
Thank you.
Thank you.
And Mr. Chair, do you want to respond before we go online?
I certainly want to work with OES on that. And,
sure.
There's supposed to be language in there about making sure that it's confidential and only used for those situations where you need to utilize it. I don't know. I think we might have Mr. Haywood from Justice Forward online.
Registered for online. Okay. Okay. Well, it does sound like there's conversations ongoing and the bill is moving forward. If it passes out today, there'll be an opportunity for that. So go ahead and turning online to hear testimony we do have one registered to speak online, and that is Mr. Brad Haywood. You have the floor.
Thank you. Just to address a couple of issues here. The main problem, I think, is the legislature knows, there's an echo, I'm sorry, knows better than anyone is that oversight and accountability has now fallen more or less to the General Assembly upon the reappointment process. It's at least perceived this way, that judges are only accountable or, or supervised or face any kind of accountability for prior misconduct at that point. Lawyers don't really file jerk complaints. I think there were only 22 lawyers who filed jerk complaints in 2024, and then jerk actually doesn't really act on many of them. There were only 4 findings of breaches of the canons in 2024. There was only 1 in 2023. So the goal here is to both increase confidence of the public and lawyers in the process, to increase and do that by increasing transparency and also by making the process more robust. I do think it's important for the jerk to get the mid-term evaluations. They're identical. I mean, as a lawyer, you fill out the exact same thing. But as Delegate Hope mentioned, we can keep working on it. I know far too much about judicial accountability right now, but I'm happy to continue the conversation. It's been a very collaborative process so far, so thank you.
Thank you. All right, and seeing no one else online, I see no request to speak from the committee, so Mr. Chair, if you'd like the final word, or?
What I'd like to do is if we can advance the bill, I want to work with OES in the meantime to make sure that we've got clarity on just what they want to do in terms of the training, judicial ethics. So there does need to be training, whether it's OES or some other entity, maybe it's the bar. We need to make sure that that is something that happens. And sharing of the midterm versus the end, we see the end. We don't see the midterm. And probably they shouldn't see anything that we don't see. But on the other hand, maybe they might. And so I think we need to have that engage that conversation. I want to go back and have a conversation with counsel from JERC. This bill had been vetted with them, these provisions that are before you, and so I'd like to get their reaction to what OES is saying. Maybe we can get everyone in the same room together and have a party. So let's do that. If we can advance this, probably full committee won't meet until later next week, middle of next week anyway. And so that gives us a full week to come to the full committee with some technical amendments, because I think this bill is very close.
Move to report.
Substitute.
Move to report with substitute and seconded. The clerk will open the roll. Sounds very close. Clerk will close the roll. The bill report's 9-0. Thank you, Mr. Chair.
Thank you, Madam Chair.
And with that, there is no further business before the committee. Can I hear a motion to adjourn?
So moved.
Moved and seconded. All those in favor say aye. Aye. We're adjourned. Thanks, everyone.